Just to add an arraignment. Mr. Trush, were you aware of this one?
I did just get an email about it, so.
Funny that we were just talking. So we're gonna need Billy to jack those.
Yes, sir.
And then I guess maybe after we take care of the first two cases, if we can take a break so I can talk to them.
Yeah. Sounds good. Okay, Mr. Musall, are you able to hear me okay?
Yes, I am. I can hear you.
Okay. All right, we'll go on the record in People versus Musall, case number 256829. The record should reflect that Mr. Musall is appearing today by video by prior approval of the court. If I could have counsel put your appearances on.
Good morning, Your Honor. Aaron Fortier on behalf of the people.
Thank you, Your Honor. Richard Trush, appearing on behalf of Mr. Musa.
Okay, Mr. Trush, can you tell me the status of this file from the defense side today?
I can, Your Honor. We're in receipt of an offer from the prosecutor. It contemplates plea to a domestic violence third and a resisting and obstructing a police officer. At this time, we're not quite there yet. But given where we're at in the case, I would suggest docketing the matter for a trial and setting a final status conference. I would not be surprised if we're able to get something done on it, but again, given sort of the bind over date and everything, I think it makes sense to get it on the trial schedule.
Okay, yeah, I agree. We're 60 days beyond bind over at this point. Mr. Fortier, do the people need any particular period of time to be ready to go to trial in this case?
I don't believe so, Your Honor. It's mainly law enforcement witnesses.
Trush?
No specific time period we're looking at. While Mr. Musel, I think is technically considered to be in the county jail at present, he's in a treatment facility, so.
Okay, so the court will set this out for trial at about 90 days. Mr. Fortier, how many days of trial do you think we'll need?
Judge, I would say comfortably, just to be sure that there's enough time to, but I think probably enough that we could get it done in one day, but I would say 2 just to be safe.
Okay, Mr. Trush.
Your Honor, I would be surprised if we take more than 1.
Okay, we'll set it for 2 days. Given the nature of the charges, it might take a little extra time to pick a jury. So we'll set it for a 2-day jury trial at 90 days out. The court will set this for a final status conference on the motion day prior to the trial date. That'll be the plea cutoff date, and any motions that either side has would need to be filed and heard no later than the date of that final status conference. Mr. Fortier, any other dates that I can address for the people today?
No, Your Honor, thank you.
Mr. Trush.
Nothing further. Nothing further on this file, though I think Ms. Davis did want to get an update as to where Mr. Musel is right now.
Mr. Musel, can you tell us what facility you're at?
I'm at Life Challenges Ministries here in Detroit.
Okay, thank you.
You're welcome.
Mr. Musel, do you have any questions about how we're going to proceed with your case?
No, I do not, Your Honor.
Okay, so the court will send out notice of the date and time of the trial dates, as well as the date of that final status conference. Mr. Musel, between now and then, it's important that you stay in touch with your attorney, Mr. Trush, and that you notify the court of any changes in your address or contact information, okay?
I will do, thank you.
Okay, thank you. The court's going to disconnect at this time.
All right.
We do not expect that.
And Mr. Roll, you understand that by pleading guilty to domestic violence third, that the maximum possible penalty you could face for that charge would be up to 5 years and or a $5,000 fine.
Yes, Your Honor.
And that by pleading guilty to resisting or obstructing a police officer, the maximum penalty you could face for that would be up to 2 years and or a $2,000 fine. Do you understand that?
I do.
Mr. Trush, were any of these offenses committed while on bond, such that there would be a discretionary consecutive sentencing?
I don't believe so.
All right. Mr. Roll, I'm going to go through your rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand that you have all those rights.
Yes.
And you understand that you're giving up and waiving all of those rights by pleading guilty.
Yes, I do, Your Honor.
Also, if you wanted to appeal the plea that you're making here today, you would have to do that by leave, which means you don't have an automatic right to do that. You'd have to ask for the Court of Appeals to hear that case. If they said no, then that would be the end of that appeal. You understand that?
I do.
Has anyone threatened you with anything to get you to plead guilty?
No one.
Has anyone promised you anything other than what we've said here in court today?
No.
Is it your own free choice to enter this plea?
Yes.
Are you pleading guilty because you are actually guilty of each of these charges?
Yes.
All right, looks like both these incidents happened on the same day. So in terms of the domestic violence charge, that involved an individual named Victoria Dort.
It did.
Okay, and did you have a dating relationship with that person at the time of this incident?
Yes, we have a child together.
Okay. And did you have some type of altercation with her?
I did.
Was that on January 26th of this year, 2025?
That's correct.
Where did that take place at?
Her apartment.
Where's that located?
The Timberley Motel.
Okay, here in Gaylord.
Yes, sir.
And what happened during that incident? What did you do to her that would make you guilty of domestic violence?
I slapped her.
And was that in self-defense in any way?
I was there getting my stuff and she wasn't allowing me to take my stuff.
All right. And then, so then you slapped her during the course of that incident?
Yes.
Had you previously been convicted of domestic violence here in the 7A District Court back in April of 2024?
That's correct.
Also in August of 2024?
That's correct.
Did the police respond to this incident there at the Timberley Motel?
No, it wasn't until several hours later.
Okay. Where did you come into contact with the police at?
I live in my van, so I was behind the Gilroy's Hardware and Lumber.
Okay, the one by the Pine Squirrel here in Gaylord?
Yes.
Okay. And did you come into contact with an officer from the Gaylord City Police Department?
That's yes.
Okay. Was that person wearing their police uniform?
Yes.
Did you know that they were there acting within their duties as a police officer?
Yes.
And those officers give you some commands or order you to do something that you didn't comply with, or what happened?
I believe he did tell me to turn around, and I turned and pointed at my van, and next thing I knew, we were on the ground.
Okay. And did he give you that command during the course of the investigation into this earlier incident?
No, they allowed me to put away an extension cord. I was rolling up an extension cord. And as soon as I hung it up, he told me to turn around. My van was wide open and I live in my van, so I was kind of concerned about that. And yeah, we went to the ground and I guess at that point is when I resisted.
Okay. And were they there, doing an investigation?
For the, yes,
Yeah, okay, gotcha. Thank you. Mr. Fortier, are the people satisfied with the factual basis as to each charge?
Yes, Your Honor.
Mr. Truce?
Yeah, sure.
Mr. Fortier, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
I'm unaware of any, Your Honor.
Truce?
I'm aware of none, Your Honor.
Mr. Fortier, are the people satisfied that the court has complied with statute and court rule for taking of this plea?
Yes, Your Honor.
Mr. Truce?
Defense is satisfied.
Mr. Roll, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of each of these charges. The court will accept your guilty plea. We'll set this matter for a sentencing hearing and be notified of the date and time of that hearing. Before you leave today, you're going to touch base with Ms. Davis from the probation department regarding a pre-sentence interview. And it's just important that you stay in touch with your attorney, Mr. Trump.
yes, Your Honor, thank you.
Mr. Truce, did you want to sign into Zoom and I can put you into a breakout room with Mr. Pickles?
Yes, I can do that.
Most of the stuff I do Home Depot. Oh, here we go.
All right, sir, can you tell me your name, please?
My name's Billy Jack Pickles.
Okay, Mr. Pickles, we'll go on the record in People versus Pickles, file number 216056. The record should reflect that Mr. Pickles is appearing today by video from Otsego County Jail. This is set for arraignment on alleged probation violation. Mr. Pickles, there is a court-appointed attorney that's available. He's signing in. I'm going to put you into a breakout room with that attorney so that you can talk to him briefly before we go with the hearing, okay? All right, just hold on for 1 second there.
Yeah.
No? Okay.
Okay, Mr. Truce, we do have Mr. Pickles connected, so I'm gonna place you into a breakout room now.
Okay, thank you.
Mr. Truce. Hello?
Yeah, just give me 1 second. I gotta get this breakout room opened up, so it takes me a minute to do that. We'll go off the record. Okay, we're back on the record. Mr. Pickles, did you have an opportunity to speak with Mr. Trush, the attorney?
I did.
Okay. Mr. Trush, how did we want to proceed?
Thank you, Your Honor. I had an opportunity to go through the allegations with Mr. Pickles. We'd waive a formal reading of those allegations and stand mute to the charges. He has been screened for and approved for counsel. Mr. Brown, well, actually, I'm sorry. I don't have the authority to appoint here. An attorney will be appointed.
Okay,
Mr. Brown was his prior attorney.
okay. And
And then we would like to address bond to the court.
okay. All right, so the court will enter a not guilty plea on behalf of Mr. Pickles with regard to all the alleged violations. The court will set this for a hearing. I should have noted at the beginning, I'm conducting this hearing on behalf of Judge Hunter. This is Judge Hunter's file, so the court will refer it to his office to be set for hearing at their next available date. In terms of bond pending that hearing, Ms. Davis, as a probation department.
Yes, Your Honor. Mr. Pickles, he didn't make it to where he was on telephone recording. He was reporting and doing well. Once he was put on telephone recording, after his arrest, he did fail to notify supervising agent of any of these arrests, continued alcohol, the allegations with a minor in a vehicle. I'm going to ask for a high cash bond, cash refund.
Mr. Trush.
Thank you, Your Honor. We're going to ask court to consider a low cash bond here. Mr. Pickles indicates he lived his whole life in Charlevoix County. He is fully employed. He indicates to me, although I know the probation department, I think, disagrees with this assertion, but he indicated to me that he has not missed his court dates. I would also remind the court, I believe that this file, he's only continuing to be monitored here because he owes some fines to the court, which he indicated he does have the ability to pay. So I would suggest to the court all of those things taking into account that he posted a significant bond already in Charlevoix County. He reports to me $26,000, that a low bond here would be sufficient to assure his appearance. Thank you.
All right, so looking at the nature of the underlying probation violations, it does allege that since February, Mr. Pickles has been arrested twice, once by Charlevoix County, once by Boyne City Police Department. Failed to notify his agent of both of those contacts. One of those involves allegations that he was operating a vehicle under the influence of drugs with a minor under the age of 16 in the vehicle. And he has been charged in a different jurisdiction with that. So the court has concerns regarding his underlying alleged conduct of public safety. And so for those reasons, I think a cash bond is warranted. The court is going to set bond of $10,000 cash surety. Again, the court will refer this to Judge Hunter's office for hearing at the next available date. And certainly a request to modify that bond can be made to Judge Hunter. He may be more familiar with Mr. Pickles than I am, but based on what I'm seeing, I think that's an appropriate bond. Again, specifically for the purpose of ensuring public safety. Mr. Trush, anything else you need to address the record today?
No, Your Honor. Thank you.
Ms. Davis.
Thank you.
Okay, thank you. That's all for today. Mr. Pickles, the court's going to disconnect at this time.
Thank you, sir.
Who do we have in the courtroom, Mr. Trush?
Wait, Mr. Eaton.
Mr. Eaton, People versus David Eaton.
File number 256824 and 6825.
Your Honor, Aaron Fortier, on behalf of the people.
Thank you, Your Honor. Richard Shrewsbury on behalf of Mr.
Thank you. This is the date and time set for a sentencing hearing in this matter. Mr. Eaton, have you had a chance to go through the pre-sentence report and speak to Mr. Church about that?
Yes, sir.
Mr. Trush, the only thing that I have, for the record, I did receive a couple of reports from months of behavioral health, reflecting some classes it looks like Mr. Eaton's been attending through there. I also received this morning a notification from Community Corrections, Ms. Van Wolfen, indicating that on May 16th, yet drug test that was positive, and then he indicated that he had used methamphetamine on May 12th. Other than that, I don't have any other additions to mention. Do you have any additions, deletions, or corrections to the report?
No, Your Honor.
Any challenges to this report?
Oh, I'm sorry. He is treating with Bear River Health Rehab.
Okay. Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Mr. Fortier, do the people have any additions, deletions, or corrections?
Other than those already noted by the court, no, nothing further than those, and no challenges to the.
Thank you. Anything on behalf of people for allocation today?
Your Honor, I think it's important to note that although, as the pre-sentence report does indicate, he's not had a criminal history or really a run-in with law enforcement up until he was 62 years old. He is 63. The one thing I do want to point out is that in a very short period of time, I mean, we're talking from December 18th to February 17th, he was arrested twice for possession of methamphetamine. It's not exactly the drug that I normally see beginners engaging in. I do know that the pre-sentence report indicates that he started with cocaine, eventually transferred into methamphetamine, which is concerning, especially with no really indicated history of usage up until his 62nd year on Earth. So it's a little concerning. I am encouraged to hear that he is engaging with Bear River. Although obviously I don't know when that started or how effective it's been up to this point, especially if he tested positive for methamphetamine on Friday. I think the usage of that methamphetamine so recent in time should probably sway the court in kind of going away from the Department of Corrections recommendation at this point, which was 12 months of supervision with jail being held in advance. I would ask that the court consider 18 months of probation with some jail up front. And I would leave it to the court at whether or not it wants to allow Mr. Eaton to engage in any sort of work for himself.
Your Honor, I would agree with Mr. Fortier. This is a somewhat atypical case. If we look at Mr. Eaton's history, I mean, to 62 years and some change of age, he's lived an ideal life. He's lived the life that we would expect someone to do, or exemplary life. He has military service in his background. He's college educated. He has a great job as a software engineer, where I believe he'll tell you he does. He essentially does contract work with the government. He's done all the right things. He has a family. He's very dedicated to his family. It's shocking to see, someone sort of take that turn at this age. And it begs the question, right? What happened? How did we get here? I've had some discussions with Mr. Eaton about this. And I think how this sort of starts is it's pressure to kind of be perfect and do everything, right? To be kind of Superman, to do everything for his kids. And his wife has some health difficulties. And, he's got a demanding job. He has a demanding family life, and his wife with her health difficulties wasn't able to do as much. So he's trying to pick up the slack there. And frankly, I think that's where it comes from, is it starts with he needs help to do all of the obligations and the things that he has, because he's trying to do the right things. Not the right way to do it, obviously, but I think it comes from that place. And I think from that place, it's gotten out of hand. And it's gotten to the point where, it's not something that is helping him to fulfill those obligations anymore. It's something that is, a crutch, and it's something that he needs help with. He's engaged in counseling. I would suggest that a longer term of supervision may be a good idea. I don't think imposing jail up front is the right response to this. Again, especially for someone with no prior history, I think we should start with the idea that we can intervene and correct the problem. Unfortunately, I think we're probably early enough in this to, I think, be able to correct the problem. I would suggest to the court, given the circumstances here, even with sort of the two offenses in a short period of time, he's eligible for treatment under 7411. I think it would be appropriate for the court to treat him that way. Again, given the lack of prior history, given, again, really that he's done all the right things up until this point, I think he deserves an opportunity to try to keep this off of his record and put it behind him. And I think that what you'll find is that on probation, he'll excel. I think he'll do well with it. And I think we have the ability to return a very productive member to our society. Thank you.
Thank you, Mr. Eaton. Was there anything that you wanted to say?
I think Mr. Trush advocated for me very well. Thank you, sir.
Okay, I did read through the report, Mr. Eaton, so I'm familiar with this circumstance and why you're before the court today. I'm also familiar with your circumstances and background generally based on the information in that report. Listen very carefully to what the lawyers had to say. And I agree with, I think, parts of what both the attorneys have had to say here. Number one, don't have a history of trouble with the law. Most of the time, people don't get to be at your point in life without that, unless they've been generally law-abiding citizens up till that point. So all the indications are that that's generally the way that you live your life up until this time. And so that gives me some reason to think that getting back to that might not be that long of a journey for you. And also gives me reason to think that the sentence in this case should be heavily weighted towards the rehabilitation aspect, which is, I agree with counsel's suggestion for a longer term of probation. I think more supervision will help. And under the rules now, you'd be eligible to be discharged early after only half of that time if you do well on probation. So I think adding a little bit longer term with the idea that if you do well, you can be discharged early is appropriate. I also agree, though, especially given what's gone on while you've been on bond and you're continuing to use, even though you're seeking out treatment, concerns me. And given your lack of prior history, I think that a short jail term so that it gives you an idea of that direction. If you don't comply with your probation, if you don't take your treatment seriously and your counseling seriously, getting a taste of what it's like to be in jail, because that would be the direction you'd be heading if you don't take things seriously at this point. And given your lack of any kind of prior history or experience with that, I'm not sure that you're taking this as seriously as you should right now, given you're continuing to use while on bond. And I think a short jail stay might help reinforce to you the consequences if you continue on this path. And I think from that aspect, it has value, not just from a punishment standpoint, but even from a rehabilitation standpoint. So the court is going to follow the recommendation to the extent that it is going to place you on probation for a period of 18 months. I agree with Mr. Trush that 7411 is appropriate, and you don't have any prior convictions that would disqualify that. And I think giving you an opportunity to successfully complete probation, have this come off your record is appropriate in what that statute is designed for, these kind of circumstances. So 18 months pursuant to 7411, the court's going to adopt all the terms and conditions of the probation. The court is going to order that you serve 30 days in the Otsego County Jail. You have credit for 2 days served. The court is going to order that you pay a crime victims assessment of $130, court costs of $325, attorney fees of $350, a DNA testing fee of $60, $68 state cost, and a supervision fee while you're on probation of $30 per month. Because this sentence is pursuant to 7411, there are no appellate rights. And Ms. Davis, if you could just update the order of probation to reflect the 7411 status. If you are remanded to the custody of the county at this time.
Your Honor, would the court consider work camp eligibility at any point?
No, again, I think it's important that Mr. Eaton serve this time based on his basically violations of this bond.
Thank you. Thank you.
Mr. Trush, is Mr. Kruger present?
He
Or is he?
in 8 county jails, Sheboygan County.
All right, I don't see them connected yet, so, and Mr. Renelette is also somewhere else, is that correct?
He is in a hospital. I don't recall the specifics of where.
We take that case now, I'm assuming he's not going to be present today.
I think that's a fair assumption.
The Court of Appellate People versus Daniel Renelette, file number 236505. Hearing was set for 9:45, it's now 9:50. Mr. Renelette's not present in the courtroom. This is set for a probation violation hearing today. Ms. Davis, the updates on this, it looks like Mr. Brunical indicated that he is in the hospital.
He is, Your Honor, and he remains in the hospital, looking like he needs surgery. So Agent Brunical is going to ask for this to be adjourned out to monitor his health.
And was this set for an actual hearing today or just a arraignment?
Yeah, he had not, yeah, he missed his arraignment, and then I believe he did not show cause for failing to appear.
Okay. So Mr. Trush, you haven't been actually appointed to the violation in this case.
Correct. I was his underlying attorney and I was present during the arraignment that he had missed. I have been in communications with him, so he did relay to me that he was in the hospital. But yes, I'm not formally appointed.
Okay, so the court will adjourn the hearing today based on Mr. Brunical's information. And then as relayed through Ms. Davis here, and we'll set this for a hearing in 60 days. From there. Still don't see Mr. Kruger connected, so we'll take a short recess.
On record, this is People versus Kruger, file number 256832.
We were supposed to have Mr. Kruger connected. They have not connected, so Mr. Truce, I'm not sure how you want to proceed today. Have you had contacts with Mr. Kruger?
I have. I spoke to him, I think, last week in preparation of today's hearing. He is still lodged, and again, I believe a writ was prepared. Admittedly, I don't recall seeing a confirmation of the writ, but I do recall seeing that one was sent. I would indicate to the court our intentions today were to ask the court to adjourn for about 30 days. We are in discussions with the prosecutor. We're in receipt of an offer, which would contemplate dismissal of the drug double, but we have counter-offered proposing a different way to resolve it, and we're still in negotiations.
Right. In light of, and it does look like the writ was prepared and confirmed, so I'm not sure where the disconnect is. But Mr. Fortier, do you have any objection to putting this out an additional 30 days?
I do not, Your Honor, and we'll go ahead and prepare a writ for the next few meetings.
Anything further on this file, Mr. Truce?
No, Your Honor.
Thank you.
Versus Jared Miller, file number 256837.
Aaron Fortier, we ask the people.
On behalf of Mr. Miller.
Is Mr. Miller present?
He is not, Your Honor. Had some difficulty in communicating with him. He apparently did not have his phone for a while. He did call my office this morning. The information that I got is he does not have a driver's license. The ride did not show up. And he's trying to walk, although he said it was about 30 minutes away, which I'm assuming is by car. He said he may be a little late. That's really all I know about the status of this.
Mr. Fortier?
Your Honor, I would leave it up to the court on the time situation.
I would also say that this is our first appearance in circuit court. If the court would be willing to adjourn, if not, I would ask the court issue a show cause.
So the court will set this for show cause. It doesn't appear that there's been any other failures of Mr. Miller to appear prior to this. The court will set it for show cause. If he fails to appear at the next hearing, the court will issue a bench warrant for his arrest.
People versus Zach Frost, case number 256833 and 6834. Ms. Davis
Did have a discussion off the record with Ms. Davis this morning regarding Mr. Frost's status. Can you make record of that, please, Ms. Davis?
Your Honor, if we're going to make a record of that, is there a chance we can go off live stream?
Sure.
Eric Hoover, case number 256840. Record should reflect Mr. Hoover's present here in the courtroom today. If I can have counsel put your appearances on in this case.
Aaron Fortier, yeah.
Larry Brown, yeah, Mr. Hoover.
Mr. Brown, can you give me the status of this file from the defense?
Your Honor, the case was very recently found over. This is our first appearance in circuit court. He does have his liaison here. He is currently in some therapy. Ms. Trish Myers back there. I've been speaking with her along with Mr. Hoover. I would request a brief adjournment of maybe 30 days so that I could go over things in more detail with Mr. Hoover, as well as maybe continue negotiations with the prosecutor.
Your Honor, I have no objections to that.
All right, given that this is Mr. Hoover's first appearance before the court will grant one adjournment, Mr. Brown. So, Mr. Fortier, can you make record of what the offer is?
Sure can, Your Honor. So the people have made an offer where if Mr. Hoover pleads as charged in count 1, operating while intoxicated, third offense, count 2, police officer assault, resist, or obstruct, and count 6, violation of driver's license restrictions, the people would dismiss count 3 and count 4, which both of those are police officer assault, resist, or obstruct, and count 5, which is open alcohol container. Motor vehicle.
Okay, and is that consistent with your understanding, Mr. Brown?
It is, Your Honor.
Okay, so Mr. Hoover, between now and the next hearing date, which will be in about 30 days, I need you to go through that plea agreement with Mr. Brown and be ready with a decision as to whether or not you want to enter into that agreement or have the case set for trial at that next hearing, okay?
Yes, Your Honor.
Then, of course, just make sure that you stay in touch with Mr. Brown prior to that next date.
Yes, Your Honor.
And that's all for today. Thank you.
People versus Paulette Jones, file number 246775.
Your Honor, Aaron Fortier, the acting people.
Larry Brown, on behalf of Ms. Jones.
trial.
All right, sir, is your name Brian, or I'm sorry, Jason Crawford?
Yes, Your Honor.
Okay. Mr. Fragel, are you able to hear me okay?
Yes, I am, Your Honor.
Okay, we'll go on the record in People versus Jason Crawford. This is file number 256844. The record should reflect Mr. Crawford is present today by video from the Otsego County Jail. Mr. Fragel is present by Zoom video, and we have Mr. Fortier here present in the courtroom. This is set for a status conference in this case today. Mr. Fragel, from the defense side, can you tell me where things stand?
We have received the CSC disc, Your Honor, as well as, I believe, all the other discovery. We'll probably have a discovery request once I review the CAC in detail. As far as a motion, I'm concerned of the 180-day rule. Mr. Crawford was arrested in Virginia on an extradition warrant in late 2024. I believe he was held 90 days. He was then released and then rearrested when the Attorney General's warrant was provided to Virginia. So he has 90 days, and then he was picked up on or about March 4th and has been held since. So I think we may have a 180-day rule. I'm not sure if the prosecutor has considered that, but we would have a motion here coming soon. And then we did file a notice of alibi defense with the prosecutor yesterday, and that'll be submitted to the court clerk soon.
Okay, Mr. Fragel, have you had any plea discussions with the prosecutor's office?
None whatsoever. There hasn't been any offer extended.
Okay, so I think what I'd like to do today then is to get this matter set for trial, get it on the calendar, and then we can build time in, Mr. Fragel, to that schedule for any motions that you'll need to file, as well as people. Mr. Fortier, are you anticipating any offers in this case?
Yeah, I believe there will be one, Your Honor. I'm not 100% certain if Mr. Rolla has talked to Mr. Herrick about it. So, I mean, I think at this point, we would keep that discussion open with Mr. Fragel. And then as far as setting the court or setting the case for trial, Mr. Rolla has indicated 4 days would be likely how long it would take for this one to go. And that's in anticipation of not only the witnesses that are already listed, but then potential witnesses through this notice that was received. In 4 days would be sufficient, maybe about 90 days.
90 days. Okay. Mr. Fragel, in terms of the length of trial, would you agree 4 days?
I believe we'll have at least 3 alibi witnesses, Your Honor. So I would ask for a full day for defense.
Okay. All right, and Mr. Fragel, if the court were to set this in that 90 to 120 day time frame, is that enough for you to be prepared?
It would. I would just point out I have a 5-day murder trial in Chippewa on September, I think, 5th through the 9th, thereabouts. And that's going to consume most of my August preparing for that. But so.
All right, would you want court to try and set this prior to that then in July, or?
I could be ready in July or the first week of August, Your Honor. Maybe the second half of July, first week of August, I could work that.
Mr. Fortier?
I don't believe there's any experts needed in this case, Your Honor. It's a testimony from the victim and her mother and significant other. And then the defendant has his version. So I don't believe it will be complex in any regard.
All right, I think the first week of August would be the best
Okay, well, it would either be the end of July, you know, my Otsego trial week is at the end of each month, so like.
That last week of July should work for me too.
All right, we'll shoot for the end of July for a trial date. If we can't get it, then the court will have to look at its next available dates after that. And we'll set aside 5 days for trial. The court will set this for a final status conference on the court's motion day immediately prior to the trial date. That status conference will be the plea cutoff. So to the extent that there are any plea discussions, that would be the last date to enter into a plea. Either side is free to file motions at any time. However, any motions must be filed and heard no later than the date of that final status conference, again, immediately before the trial date. Mr. Fortier, any other scheduling matters I can address from your side?
No, Your Honor.
Mr. Fragel, any other scheduling matters I can address for you?
No, nothing for scheduling, Your Honor. As far as the preliminary exam transcript order, should that go through the district or the circuit at this point? It was created in the district.
Yeah, I think you would need to submit that to my office.
Okay, will do.
Okay.
Thank you.
Mr. Crawford, have you been able to hear everything we've discussed?
Yes, Your Honor.
Do you have any questions at all?
No, Your Honor.
Okay. All right, the court will send out notices of the date and time of the trial as well as the final status conference. And that's all for today. Mr. Fragel, you're free to disconnect at this time.
Thank you.
All right, the court will recall People versus Miller, file number 256837. Miller here? Yes, Miller. Mr. Brown, how did we want to proceed with this file?
Your Honor, notwithstanding, this is our first appearance in circuit court here, and there has been a misdemeanor plea offer. We are going to request that this matter be set for trial. I would also request a final status conference.
Okay, Mr. Fortier, can you tell me what the plea offer is? Offer
Is if Mr. Miller pays $6,750 at or before the time of sentencing, then the charge would be reduced to an added count 2 of false pretenses, over $200 but less than $1,000, which is pursuant to MCL 750.2183A. That's a 1 year or $2,000.
All right, so the court will set this matter for trial. Mr. Fortier, how many days of trial?
I believe 1 day is sufficient.
I would agree.
All right, so the court will set this at about 90 days for a 1-day jury trial. The court will set it for a final status conference immediately prior to the trial date. That's motion day. So Mr. Miller, between now and the trial date, there will be one final status conference like we're having today. That date would be the plea cutoff. So to the extent you wanted to further consider any plea offers, that would be the final date to do that, okay? The court will send out notice of the date and time of that hearing to you as well as the trial date. It's important that you stay in touch with your attorney prior to both of those dates so that you're prepared for court, okay? It's also important that you're here on time, particularly if we're going to go to trial.
Yeah, my apologies for that.
Mr. Brown, anything further we need to address on this file today?
No, Your Honor. Thank you.
Mr. Fortier?
No, Your Honor, thank you.
Okay, thank you. That's all for today.
Good morning, Your Honor.
Okay, thank you.
I'm hearing at 11 before this one.
Okay. Sounds good. Thanks.
All right, looks like we've got everybody connected, so we'll go on the record. This is the matter of the Corn Family Limited Partnership. File number, Charlevoix County, file number 03-1723-19-CB. Again, I'm sitting on this case by assignment. If I could have, excuse me, all counsel go through and put your appearances on for purposes of today's hearing, please.
Good morning, Your Honor. Kevin Smith, appearing on behalf of the Chapter 7 trustee, Homer McClarty.
Dean Nelson, on behalf of the other Chapter 7 trustee, Basil Simon.
Good morning, Your Honor. Howard Shear on behalf of Sheldon Korn, Gail Korn, and Shauna Korn.
And good morning, Your Honor. David Cleavorn, appearing on behalf of Ashley Byron, formerly Ashley Korn.
Your Honor, David Finling, I'm the court-appointed receiver.
Okay, thank you. We're on the record here today for a status conference in this case pursuant to the court's most recent order back in January following a hearing. The court had set this as a control date. The parties were going to attempt to reach a stipulation regarding the filing of the disputed tax returns in this case. I did just recently, May 7th, sign an order, stipulated order in that regard. So my view is today, probably we just need to set another date going forward. But given that stipulation, I don't believe that there's anything substantive that needs to happen today. Is there any counsel that would disagree with that?
Not from the receiver.
Okay. All right, great. So I guess the question is then, how far forward do we need to set the next status conference? And I would just open that up to counsel, whoever wants to jump in on that first.
This is Dean Nelson. Mr. Bull indicated that it is his goal to have these tax returns done by the end of July. You know, I assume, like much in this case, we will probably be delayed beyond that just because it seems to always happen. So I don't see a reason to have a status conference before August, mid to late, maybe even into September, is my personal opinion. Subject, obviously, if there are any disputes that need to be brought before the court, we would obviously have to file a motion before that time.
Okay. Anybody disagree with? I'm thinking like a mid-September date, just to build in a little extra time there. Does anybody have any objection to a mid-September date for the next status conference?
Your Honor, this is David Finling. I don't have an objection. I just think that we may be back with another example of today. If the returns are done in July, knowing the lack of staffing at the IRS, I believe it'll be months before they actually review the returns. And I don't know how much we can accomplish until we get some type of response from the Internal Revenue Service. So I'll leave it to the court how it wants to manage its docket, but I don't think we're going to know much probably till the end of the year, but whatever the court deems appropriate.
Okay. I guess my suggestion would be then, I'm going to set it for the mid-September as a status conference date. If counsel, if you all agree that there isn't much to be done based on the status at that point, then I certainly would be open, to a stipulated order adjourning that out to a later date after that, so that everybody doesn't have to appear. But that way, at least there's something at 120 days out, which I think is a reasonable time frame for all of us to keep tabs on this case to make sure that it's moving forward. If there are issues, then we can address them at that time. But Mr. Finling, I agree, if it doesn't look like there isn't anything substantive we can do, then I have no issue with, if everybody agrees that that's the case, to stick to a stipulated order moving it out. So that's how we'll proceed. I will indicate that in a scheduling conference order and send that out to the parties today, along with the date and time of that status conference in mid-September. Is there anything else that I can address for anyone while we're on the record today? All right, I think we just set a record for the quickest hearing that we've had in this case. So that's good. So hopefully things continue moving forward. I appreciate council's work in reaching that stipulation, and everybody's free to disconnect at this time. Thank you.
Thank you,
Thank you,
John.
Your Honor.
Thank you, Your Honor.
All right, Mr. Hill, are you able to hear me okay?
I am.
Okay. We'll go on the record in John Ryan versus Secretary of State. This is file number 2520043. Counsel, if I can have you put your appearance on the record.
Good morning, Your Honor. Ryan Hill, P68445 on behalf of Mr. Ryan. John, state your name for the record, please.
Good morning, I'm John Ryan.
All right, thank you. We're on the record here this morning based on Mr. Ryan's petition for restoration of driver's license based on an implied consent suspension for hardship. So Mr. Hill, I'm going to place your client under oath. I typically have counsel, use a question and answer format to establish the basis. And then after that, Mr. Hill, if you have any argument, I'll allow that, okay?
Sure. Am I going to do the voir dire, Your Honor? If I am, then I apologize. I'm not sure what to ask him.
All right, well, in order for the court to grant a restricted or full license privileges, the court has to find that there's an undue hardship.
I understand. I can do that.
So, yeah. All right. Mr. Hill, can you raise your right hand, please?
Mr. Ryan, you mean?
I'm sorry, Mr. Ryan.
That's right.
I've got two, your first name's Ryan, so I'm looking at the wrong. So Mr. Ryan, do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I swear.
Thank you. You can lower your hand, and Mr. Hill, proceed whenever you're ready.
Mr. Ryan, obviously you pled guilty to an operating while intoxicated or visibly impaired recently, correct?
That's correct.
Okay, and you were given a notice from the Secretary of State as it relates to an administrative hearing. Do you remember getting that?
I believe so, yeah.
Okay.
Or was that the one that got? There was one that was I got the one the post service was down. I didn't
Yes.
get that one. Was that the one we're talking about, or is it
Yes.
that different one?
Yes.
Yeah, I got that one later to the date it was prior to my actual court date was.
And you missed the hearing, and that was because, as we put in our appeals, because the Canadian Postal Service was down during that period, wasn't it?
That is correct.
Okay, and that's the sole reason why you missed the actual hearing, correct?
Yep.
All right, and currently you're a full-time student at St. Clair College, is that accurate?
Yes.
What are you studying?
I'm studying civil engineering.
Okay, and you currently live in, I think it's Stony Point, correct?
Yep.
All right, that's about I'm familiar with the area, being Canadian, that's about 40 minutes from St. Clair College?
Roughly 40 minutes, yes.
Okay, and you're also working in construction, is that accurate?
Yep. Leo Mayu Construction.
All right, and did you have any other means to transportation as it relates to school and work? I'm sure you've been making do currently, but has it caused a hardship in terms of your license being suspended in terms of transportation?
I would say it has caused us problems, and it also has cost me money on if I don't have a ride, if I don't have someone available, I have to spend $20 to $30 on an Uber somewhere, and just things like that.
And any prior infractions? I know we pulled your ministry license. Do you have any other convictions like the one that you pled to here in Michigan?
No.
Okay, and your driving record for the most part is clear. Is that accurate?
I don't even think I have a parking ticket.
Okay.
No, I
And
don't.
and prior to your actual plea, we had an alcohol assessment done. You remember doing that?
Yep.
Okay, and the alcohol assessment came up somewhat positive, didn't it? Saying that you did not have any alcohol-related issues. Is that correct?
Yes, it said I was very low risk for doing what I did again.
And the district court judge implemented some sanctions and or some things to do, and you completed those. Is that accurate?
Yes, I believe I created I completed a 12-hour drunk driving course, and then I did Mothers Against Drunk Driving as well. I completed both courses.
And not to get into the facts of the underlying offense, but was it safe to say this was an isolated incident?
Yeah, it's something I definitely would not do again. It was for sure a mistake, and I've learned a lot from my mistakes. I paid for my mistake, and I just want to let the court know that it won't happen again.
Okay. Did I touch everything I needed to touch, Your Honor?
Yep, I do have a couple additional questions. Mr. Ryan, when was your sentencing hearing on your charge?
I believe it was the final date where we were here in January. I believe it was January 16th. I believe.
Okay. All right. Were you placed on any kind of probation or did you just get a straight sentence?
I don't think I was placed under probation, if I'm not correct. I think I was just assigned to the courses that were recommended by the court.
And that's correct. That's correct, Your Honor. It was no probation because of the assessment that was submitted to the court. He was just given some additional things to do, like the classes, and he completed those.
Okay. All right. And Mr. Ryan, you're a Canadian citizen, is that correct?
That is correct.
So you don't have a Michigan driver's license, but I understand from the petition that the suspension here affects your Canadian driver's license.
That is correct, Your Honor.
Okay. All right. And based on the conviction itself, I'm assuming that the Canadian government finds out about that in some way. Does that affect your license, your Canadian driver's license? The fact outside of this suspension issue, does your conviction in any way affect your Canadian driver's license?
I can address that, Your Honor. Just because I'm also Canadian, it does. When we pled, we knew that the operating level was impaired would not affect his license. He'd be given a restricted. The problem was the administrative hearing that he missed. We were unsure by him missing it if it would actually abstract to the ministry, but it did. In Canada, a drunk driving equates almost to a felony. It's a little bit different. So there is going to be potential license, not sanctions in terms of suspensions, but if he was to get something equivalent in Ontario, it's not good. It's like I said, it's almost equates to a felony, anything alcohol related, but it's the administrative hearing, him missing. It's the one that abstracted. This is the first time in 20 years I've had this happen with a Canadian client, but if it was a visibly impaired and he hadn't missed the hearing, he'd be fine.
Okay, so his Canadian license wouldn't have been affected.
If he wouldn't have missed the hearing, it would not have been. He would have given the same restricted restrictions as Michigan would have given on a visibly impaired.
Okay, all right, understood. Okay, so I've had a chance to review the file and the petition. I've had a chance to hear Mr. Ryan's testimony here today, along with some clarifications, because this is a unique circumstance. And in 12 years on the bench, I haven't had this one come up yet. So I wanted to make sure I was clear on the interplay between the Canadian license and the licensing sanctions here in the US. So looking first at the standard of unduly burdensome or an undue hardship, typically the court looks at the specific instance, circumstances of the person who's filing the petition. Obviously, any suspension of a driver's license in today's day and age is going to present some type of hardship for the individual. And so what I'm looking for is a hardship or a burden that's over and above what would be considered a standard hardship or burdens of not being able to drive. So just simply things like not being able or making it more difficult to go to work or go to school, in my view, is pretty much a standard, consequence that everybody who faces suspension has to deal with. So I'm looking for something over and above that. I do think that Mr. Ryan's case does meet that standard, though, for a couple of different reasons. Number one, he does reside a significant distance from his school, and the court finds that Mr. Ryan being able to continue to pursue his education, given that he doesn't have any prior convictions or any history of this type of offense, given that this does appear that he was here on a trip, probably outside of his normal environment and maybe engaging in conduct that he doesn't normally engage in, the court finds that it's unlikely, or I don't have concerns that this is conduct that he regularly engages in to the extent that he presents danger to the public. And the court finds that there is an element of hardship here that is present, that isn't present in a typical circumstance. I also think another mitigating issue is, his ability to contest this through the driver's license appeal division, given the difficulties that were experienced regarding his receiving a timely notice, and that he's kind of been penalized for something that really wasn't within his control and would have otherwise resulted in a lesser sanction. So for all those reasons, I do think it's appropriate to grant the petition. And so, Mr. Hill, will you present an order to the court, and the court will sign that once it's been presented?
Thank you. Do I mail it in, Your Honor? Can I email it? What's the protocol?
Yep, I think you need to use regular mail and send it to the clerk's office here in Otsego County, and the court will sign that.
I will do that. Thank you so much, Your Honor. I appreciate it.
Okay, thank you. That concludes this hearing, and both of you are free to disconnect at this time.
Take care.
Thank you, Your Honor.